Ladies and gentlemen, good afternoon. Welcome back from lunch. I'll try to be a little upbeat. I know it's hard to stay awake sometimes right after lunch. I think this was my time slot in the opening slot time frame as well. So hopefully we can recreate that. I want to thank you for the time you spent. This has been a long, arduous voyage, right? From voir dire, from that first Monday morning till now, but we are coming to a close. So again, along with brother counsel, prosecution, the court, I'm sure we all appreciate the fact that you're still here with us, okay? And I'll say this now because I won't get to speak to you again. For the 12 of you that sit in judgment of this case, thank you for going that next step. For the 2 of you that will ultimately be drawn out, thank you for being here, right? I often wonder, I've never been in that spot, but I've often wondered, would I rather be drawn out and get to go, or if I sat this far along in a trial of this complexity and length, would I want to stay? So either way, thank you for your attendance. I've watched all of you. You're very engaged. I see a lot of note taking, which again, both sides appreciate. So thank you very much. I think one of the very first things that you were told at the start of this trial was, this is a very simple case. And I think you can agree with me at this point, as it has followed its way down the river, this has not been all that simple. There have been a lot of twists and turns and jagged edges, if you will, that make this not as simple maybe as it was originally portrayed to be. But the one thing that we can all agree on, prosecution, defense, the court even, that these jury instructions are what they are, right? You were told about them in the beginning. You were told about them during opening statement. Madam Prosecutor, Madam AG, made reference to them. Mr. Johnson made reference to them. At some point, I may come back to them during this. But the key to this, why I'm bringing this up for you and what I need you to recall, and we talked about this extensively during voir dire, right? There are elements to every crime, and you've got to get all those elements. We can't backtrack and go, well, they got 4.9 out of 5, close enough, right? You've got to find that if there's 5 elements in this charge, that they meet all 5. So I ask you to remember that we talked about this and don't sell it short. Why do I bring that up? Because as this has unfolded, as the testimony has gone on, certain aspects have been presented that could make you go, well, okay, I see. But the problem is, and as Mr. Johnson pointed out, when you go chronologically through these, when you go step by step through these, when you read the entire document, as Mr. Kirkpatrick come through, right, in the testimony, and you put it all in context, which we've also spoken about in the past, there's a big difference to what you see and what you get. So think about it, if you will, like making a cake. You've got to have all the ingredients, or it's not going to come out as a cake. And that's what you've got to have here when you go back in that deliberation room and consider this. And one of the jury instructions that you're going to hear talks about, and I believe Mr. Johnson spoke about it, is credibility of a witness, right? One of the things you're going to be told by the judge in the jury instructions, and again, you'll have these to take back with you, is how was that witness's testimony presented, right? Was it clear and concise? Or as Mr. Johnson said, did they argue with the lawyers? Did we have to extract information from them, if you will? Did we have to go to the transcripts and take it up and ask permission to go there and go, here, now I'm going to read this and you're going to respond back? And sometimes we had to do that 2, 3, 4 times to get to what was actually previously said. And that's some of that argument back and forth, as Mr. Johnson again referred to it, right, as rehearsed testimony, right, making it fit the narrative. Well, don't let it fit their narrative, because their narrative isn't necessarily the truth. Just because they say it doesn't make it so. Just because the state says, well, this is what took place, that doesn't make it so, right? We heard a lot of talk about the boog and the boogaloo, the big dance, but we never really got to Is there any other explanation for this? Right? You weren't given it. And remember, reasonable doubt is the evidence and the lack thereof. So when we hear all this talk about the boog and this coming up, there was a lot of national dissent, right? Go back with me before the pandemic, right? Go back to 2019, go back to 2018 if you want. There was national dissent, red, blue, there was no purple in this country anymore, right? You believed this or you believed that. But for many people, they could sit back and go, is the grid going to collapse? Is this social society going to fall in? And that's where this boog idea comes in, right? What do we have to prepare for? So every time they put up here, and this Datamani this morning kept showing you, right? She put it up. Oh, here they said defense. Here they said defend. Here they said defender. But that's not what they mean. Why is that not what they mean? Right? How do we know that's not what they mean? Don't forget, these were encrypted communications. These were encrypted communications that were self-deleting. They had no reason to lie about this. So if one of them says to one of the other members, well, let's not forget, this is a defensive group. They're not putting that out there in anticipation of having to sit here. They're communicating amongst themselves. So when they say, look, we're a defensive group, and this is about defense, and we're here to train for defense. And just because the Attorney General says that's not what that means, why? Who were they communicating to but themselves? They weren't writing this thinking that Agent Impla or Agent Arliss or Agent Chambers or somebody was reading this. They're communicating to themselves. So when they say this is about defense, that's genuinely what they talk about. You heard Dan, after some teeth pulling, finally admit that he was the one doing the training. Right? His first testimony was Joe. Right? But then we got to the part, and I took the transcripts up there, and he had to admit, right, it was him. But then he also, in that same kind of conversation, had to come back and say, yes, Joe did say, come into my house, teach me how to defend my home. Right? And show me what I need to do to defend myself. Where's the offense in that? Where's the agitation in that? This is, I'm trying to defend myself. I have a family. I have a wife. I have other people that live here. You're the expert at this. Come show me. You recall that, right? That was the testimony from their witness from that stand. Again, once we were able to extract the reality from him. If you recall, and this is where I'm going back to the credibility issue, right? Dan testifies, well, there was a leadership meeting and it just kind of, they talked about it. And I said, wasn't there an election? Weren't you voted leader? No, that wasn't me. There wasn't a vote. No, but then we hit the transcript, right? And we take it up there. And what does he end up having to say? Yes, there was a vote. Yes, I was voted the leader, but I didn't accept. Well, but that's not the same thing, right? And if we're going to have all these inconsistencies, which one do we take? Do we take the one that was here presented to you by the AG on their direct examination? Or do we go back to the other times he's appeared in a courtroom before a judge under oath and said something different? If the truth is the truth, it will stay the truth. You don't have to be reminded of the truth. I don't have to come up and go, hang on, is this what you said before? And then wait for an explanation. Mr. Johnson did a fine job saying, well, this is what he would respond, and this is what he responded. And again, you're finally having to extract this information. That's the credibility that His Honor is going to caution you about in the jury instruction. Listen to what was said and the demeanor in which they gave it. Were they in a position to know what they were talking about? Well, I would tell you Dan was. He was in a position to know if there was a vote or not. Why couldn't he just tell me that the first time I asked? There's an issue with that, right? There's something intrinsically wrong with taking a 180-degree turn about what we're talking about. There was an issue, I'm sure you remember it, right? Where I got into it with Dan over his military service, right? And my issue is not with whether he went to Iraq or not. My issue is not, was he in the Army or not? My issue with that was that every time they paraded Dan in all these different testimonies, the combat wounded warrior. No, that's not true, right? And you heard it from him. He did not get a purple heart. He was not wounded. He was hurt thanks to Mr. Patrick's cross-examination in an ATV accident that he then took to the VA and said, oh, but I fell down when I was in Iraq, right? I'm not disputing his combat experience, right? It is what it is. It's on the paper. But why do we have to go through this pumped up puffery, if you will, LARPing, as maybe we could call it, right? As to why you didn't just say, well, yeah, I'm a combat veteran, right? If they just said that, I'd have been like, okay, I hear you. But when we want to present it in a different light, you have to ask yourself, why do we need to present it in a different light? Which takes me, and I hate to tangent off, but I'm gonna. You were told this morning that when people raise their voices, it's because they don't have the truth. Well, maybe they just are fed up with it, right? Maybe there's a disgust behind or an animosity behind it because they're having to fight through this rather than just going, here's the question, here's the answer. Here's the question, here's the answer. Or maybe there's just an animus about this case in general. Because when you read it and you look at it from our perspective and you just go, how did we get here? From this half piece of testimony and this half piece of a text, and we're not going to give you all this. And the prosecution has said this to you numerous times, and this is where I get, again, angry and frustrated with this process. They want to say, well, we gave everything to the defense. If they want to show you something different, they can. Is this about seeking justice and finding out what happened? Or is this about going, this is our story. If they want to tell you something different, they'll find it and tell you. Think about that for a second. And then ask yourselves, is that what caused these gentlemen to really question what's going on in this society? Right? We hear testimony about, oh my goodness, they had the Anarchist Cookbook, book written by a teacher of special education children, by the way, right? But something the FBI's own documents say is protected First Amendment speech. It is mass produced, it is available, it is protected First Amendment speech. Yet we're going to draw something from that. There's something inherently wrong with that if I can take something that is protected and use it against you, right? We have taken the Constitution in this case and just basically shredded it. They want to bring up the fact that my client was arrested. Yes, he was. What was the very next part of their statement? And he went out and he hired a big time lawyer. I'm sorry. I thought in this court system, in this country, you have the right to be represented by counsel. And he didn't seek to do it on the county's dime. Right? He didn't go, oh, I ain't got no money. Give me a court-appointed lawyer. He went out and he hired an attorney, which was his absolute right to do. And which, what I would tell you, is most reasonable. He's not a lawyer. You heard testimony. He's a chimney sweep. At that time, 24, 25-year-old chimney sweep. What does he know about the law? Right? So he goes and he gets a lawyer. Then they want to make it out, right? Agent Impala said these exact words. He got a sweetheart of a deal. No, he didn't. He got the same deal that Trooper Tasker told him. This is what's going to end up happening with this case. He got the same deal that Trooper Rainey told him. This is what's going to happen in this case. And guess what? This is exactly what happened in this case. A misdemeanor and a $75 fine. And let me correct something, because I thought I told you in opening, I thought it was $250. No, it was $75. A $75 fine. son got a ticket a year ago for not wearing a seatbelt on the floor. That was $110. So not wearing your seatbelt carries a $110 fine. This horrible crime that Joe committed was $75. Was he angry about it? I guess, right? And I don't blame him. And I don't have an issue that he called to complain about it. Because ask yourself this, why are the troopers arresting people for felonies when they immediately tell you within an hour, because that's all the trooper told you he spent with Joe, this is going to be a misdemeanor. Well, if that's what it's going to be, charge the misdemeanor and let's move on, right? Let's not inflate this into something it's not. Again, that's one of the issues that people keep having with the government. Why are you doing this to me if this is where we're just going to end up? Just do this and be done, right? Why run me into the ground? Why run me into all of this if this is where we're going to end up anyway? And again, Trooper Tasker told him what was going to happen. Trooper Rainey, this mentor, that's what she told him was going to happen. And in the end, that is exactly what happened. You heard Ms. Dottamani tell you about entrapment. This isn't an entrapment case, right? There's going to be a jury instruction. The judge is going to tell you, right? It's going to be part of it. Entrapment's an issue of law, not fact, not for you to consider. But when I tell you these are the things that Dan did, I want you to see it from the light of, how credible is what we're getting. As Mr. Johnson called him, the $54,000 man. Right? We're told to believe that this $54,000 didn't cover his lost wages. Again, he made $60,000 a year. He got $54,000 for 17 weeks. I wasn't a math major. That's why I'm a lawyer. But I know that somehow that equals out to be more. Right? And they want to tell you, well, it was being reimbursed. Right? I'm being reimbursed for my costs. That's what they represented. That's what he tried to testify to until what? Until again, I had to pull out the transcript and show him where his previous testimony was he was selling information. And that's what he said from the chair. Again, once we extracted it, once we pulled out the documentation and said, I'll read the question, you read the answer. And then he had to admit, yes, I was selling information. So again, where do we stand with this, right? Where is the truth in all of this? Dan wants you to believe, the AG wants you to believe, Facebook reached out and grabbed Dan and said, here you go. Facebook somehow knew this is what Dan was looking for. You've heard me say this more than once, right? I'm no computer genius. I don't follow it. I'm old school, right? I have a desk calendar I write on. I have a calendar book that I write on. But I think I can understand this enough to know that you had to put something into Facebook in order to get there. Was Dan looking for training? Maybe yes, maybe no. What I believe actually, and I think what the testimony would bear out if you consider it, is Dan told you he's a professional trainer. He gets paid to train people. That's what he said. Right? And he will go to your house and I'll conduct the classes and I'll charge the other people and you let me use your land to teach you. Right? That was his testimony, their witness, his testimony from the stand. So was he just randomly out looking and Facebook reached out and grabbed him and said, oh, hey, this? Or was he looking to build his resume, apply his wares to the highest bidder? Was he looking to get paid? I don't know. That's a decision you've got to make. But ask yourself, what sounds realistic? What sounds reasonable in this event, right? that the professional trainer found a group that was looking for training, or that Facebook did this? I think it's the first, right? I think he was looking for someone to train. He was looking to make some cash. Nothing wrong with that, right? Professional trainer, someone's got to do it. But then this is what he does. He finds them on Facebook. He signs in. Now, here's the crux, and I told you this again in opening. The alpha and the omega are missing from this. The alpha being he sees all this stuff on here, and he runs to all these professional law enforcement officers. He runs to Officer Ramirez, who goes to the sergeant, who goes to Agent Impala. And none of these professional law enforcement officers thought to capture this because we can't take a screenshot. That's what you were told. But I think if you remember an opening, right? Here's the phone, here's my phone. I can take a picture. Officer Ramirez, 25 years on the job, didn't think to go, I should capture this. This might be important. Doesn't bear out. Doesn't pass the smell test. Makes you just go, really? Was it even actually there? Or is it Dan filling in the blanks as he's telling the story? I think that's a lot more likely, that he was filling in their blanks as to what they knew. We were told in opening, and it was re-emphasized here during the prosecution's case, that these guys sought out Adam Fox. Nobody was seeking him out, right? These people, in a defensive mind, seeking defensive postures, seeking to defend themselves. Again, their words, right? They made a big point. Let's use their words. Well, their words were defend. They meet these people. They're easily taken in, right? Oh, this is what's going to happen. Society's going to fall apart. And I told you this too, right? You can't turn on late night TV and see all these survival groups, right? Buy food. It's on your shelf for 50 years. Do this, do that. It's all coming to an end. And all of this buys into these people, and I go, I don't know. So they're not looking for a terrorist to train. I think to say that is pretty disingenuous, right? Nobody was sitting around at the Dunn Road property going, you know what? Let's go find a terrorist. Yeah, it doesn't pass the smell test. You say that and you go, no, that's not how these things happen, right? So again, give me all of it. Don't give me a part. Don't give me your depiction. Give me it all. They find these guys, they come together at some point in time, but it's not about training a terrorist, right? They bring him in. And when I say they, again, ask yourself who's they, because their own witness finally, after a while, had to admit that he's the one that vouched for Adam Fox. He's the one that told Jada, oh, this will be okay. Come on, we can make this work. Again, not entrapment. Credibility. What's his story and why? Right? Let me bring this all in. Let me bring it. Do you remember I went back and forth, back and forth, back and forth with him? Did you invite him? Well, I just suggested. Okay. You are the voted leader, and you're suggesting I come. And then the voted leader goes to Joe and says, Joe, this is the way to go. And then if you remember, I told you he was going to go to Joe's wife, and that's what he did. Gets Jada on the phone. And finally they acquiesce, and he comes in. Joe's not a leader. He's just not. He was angry. He created a Facebook page. He put up some memes and posts that we've all agreed, right? Some are in bad taste, but First Amendment protected speech. But what kind of leader of the Boog for Michigan can't attend this function, can't attend this training, can't attend this, because his balls are in his wife's purse? Their witness on the stand, right? He couldn't go. Sorry, I can't go, right? He's not going to tell these guys. He's not going to go, I can't go. My wife won't let me go. But let's face it, he disappears, takes up, he eliminates the wire. He does all. Why? Again, Ms. Dottamani gave it to you this morning. She showed you the exhibit. He was gone. Why? Because he's having domestic problems. So they want to tell you, right? This is his focus. This is what he's doing. This is why he quit, being a reservist. No, he quit because his wife was in his ear, right? She's henpecking him to death. I don't know what their domestic problems are. I got an idea, but I'm going to let it go because I don't know. But either way, that's his focus, right? He's gone. He disappears. You heard testimony, again, from their witness, Dan, Ty Garbin, complaining. Where's Joe? Where's Pete? Why are they not involved? Why are they not active? Well, because they weren't. This wasn't this driving force of their life, like the AG wants you to think. It just wasn't. Joe's got a family. Joe's trying to figure things out. Does Joe want something better for his life? Maybe. I don't know. Does he want to be involved in something? I don't know. Maybe. But this isn't it, right? If it was, he'd have been like, take my balls back and I'm going to do this. That's not what happened. Right? You heard testimony. Their witness, that witness stand. Did Joe attend this training? He had to go to the zoo. Not the big time driving force for this mujahideen person, right? I would tell you the term they used, LARP, that's exactly what Joe is, right? A live action role player. He wants to do this, but it's not happening. You heard testimony. Again, their witness on the stand in August, months after this June 28th training where everything came together, the one we don't have the recording on, by the way. In August, Adam Fox tells their witness, who he had to testify from that stand, Adam Fox tells Dan, Joe doesn't know the plan, and if he did, he wouldn't be down for it. You remember that? You heard it, right? It came from that stand right there. Joe doesn't know what the plan is, and if he did, he probably wouldn't be down for it. Now, a couple of days later, they're in Munich, bunch of guys sitting around, right? One out doing the next, and Adam says, this is the plan. Are you down for this? And you heard Joe go, yeah, I'm down. What's he supposed to say? Right? This LARP sitting there, whose wife carries his balls around, is he going to stand up to this group of guys and go, no, I am not doing this? He goes, oh, yeah, okay. But then we fast forward, and again, it's crickets. He's having to sign into his own group and go, where's everybody? It's crickets. I know I haven't been here, but it's crickets. Because there's no group, there's no gang, there's no nothing. It's a collection of people trying to find some common ground in something. There's no gang. Think about what a gang is. I know we can put this up here and say, well, this is what it means. Okay, constant communication with each other. If I sign in and I go, this is crickets. If I got members of the gang complaining that I'm not around, I don't know that you can say I'm in constant communication with anything. Right? It's not there. So we can string this along and we can make these leapfrog inferences, but that does not make it so. Again, just because the AG's office tells you this is what happened, You got to ask yourself, what did you hear from their witness on that stand? And it's not just Dan, right? We heard testimony, and Mr. Johnson brought it up this morning. One of the agents said, I'm going to run this like a TEI, terrorism enterprise investigation, whether they like it or not. I'll beat them over the head with it until they give it to me. So let me see if I understand this correctly. The supervisory group says it's not there, but you're going to over the head with it until you convince them. And what was Agent Empla's testimony about that? Well, I didn't know about that till the end. Maybe we should have heard from the person who did know. You heard testimony, there were 400 reports written in this case. I think Agent Empla testified he wrote less than 20. So what's in this? Where's the rest of this? Where's the rest of the story? Why don't we get that? TEI, we're going to do this no matter what? I didn't know. Okay. As Mr. Johnson pointed out, it was good for the goose, it was good for the gander. The agent in charge did not know what was going on and what was being said and what's in these 380 other reports. How do we impugn that to say this collection of guys just know everything and this is their focus? And how do we even say this is this collection of guys? Everybody that they talked about, they wanted to lump into be a Wolverine watchman. They talked about Sean Fix. Well, Sean Fix was there and he was one of the watchmen. Sean Fix was never one of the watchmen. And you heard that testimony again. Once we were able to extract it, Sean Fix was connected to Adam Fox. He was never connected to the watchman. But if I say he's part of the watchman, there's my group. There's my gang. That's not so. Because they say it doesn't make it so. You heard different words from the witness stand. And that's where the testimony comes from. We were told in opening that the whole purpose of these trips to the Capitol was to recruit. Recruit. They didn't put on one person that they got in this recruiting trip. Maybe it wasn't recruiting after all. Maybe it was the protest that the lieutenant told you it was. A plan, a scheduled protest at the Capitol. And it wasn't just the watchmen that were there. It wasn't Paul, it wasn't Joe, and just Pete. Right? It wasn't the three of them that were there. I think he said a couple of hundred people were there. And if you recall during voir dire, I made the point of saying, right, it doesn't do me any good to protest the government by standing in my backyard and stomping my feet. Right? I have to go to where the government is to voice my concerns. And that's what these guys did. Lawfully, legally. With the tools they were lawfully allowed to bring in. So again, why do we want to make a big issue out of it? Because that makes our story better. If we take the book and we get everybody on the page and here's the next chapter and here's the next chapter, this is how we fill it in. By giving you this. By telling you they were there on recruiting business. No, they were there complaining. They were there protesting, as was several hundred other people. Nothing wrong with that. Nothing wrong with seeking redress from your government. They want to tell you that, well, look what they did. They kept calling the governor's office. Okay. What's the line set up for? They weren't calling her on her personal cell phone at 3 a.m. going, hey, this is what we think. No, they were using the line set up by the governor of the state of Michigan for people to call and complain. And what's the one call they showed you? Right? Joe is calling to complain about red flag laws. And the Statamani said, well, there's no red flag laws in Michigan. Right. But if you watched the debate the other night, it came up again. It's obviously an issue for people. Right? People have a right to call and say, I don't agree with this, right? Because nobody calls and agrees. How's the governor supposed to know? So why show you this slide where my client called the governor to complain about a red flag? What's you supposed to do? Tie it to a pigeon and carrier pigeon and send her a note? No, the line is set up to get response from the governor, and he utilized it. Not a crime, and certainly not the OPSEC they want you to believe, right? I'm not going to go out and parade around in the Capitol. I'm not going to go out and parade and call the governor's office, and I'm not going to do all this. I want to be undetectable, right? So they do training in Munich, right? Let's fast forward to that. Yeah, they did training in Munich. They did training before. They did some training after. Joe is not a convicted felon. He's free to be on his property shooting his gun, right? Dan is there doing the training. He's teaching. So again, so what? They don't know Adam Fox. They get him. Their voted elected leader says he's okay. He's okay. We're just going to come do some training. And as Mr. Johnson pointed out, right? Guys on their land doing what they like to do, shooting guns. No big deal, right? It's not the nefarious thing that they want to make it out to be. Why? Because you also heard the testimony, and I'm sure Brother Counsel here is going to bring it up, right? When you look at the entire sentence, right, the domino effect, and I'm not going to steal any more of that from him, but right, but what was that? The domino effect. We're going to kidnap this governor, and then this state, and this state, and this state. No, that wasn't really it, was it? You heard the testimony again from their witness. That really wasn't what was being talked about, because that's not what's in the entire posting. Look at the entire posting. Right, there are thousands of pages in those binders that you're going to get. And they know you're not going to pull them out page by page by page and read them. Right? That's why they can show you the little black box. Just look here. Just look at this part right here. Right? That's what they know. That's what they think they can tell you, and that you'll listen to. They want to keep telling you that this training is offensive training. But if you remember in Cross with Dan, I talked to him about MOUT training, military operations in urban terrain. And he finally, after a while, I had to come clean and go, yeah, I mean, this is not, it's kind of generic, right? It doesn't have to be offensive. It was a struggle. But what you're doing, and again, as Mr. Johnson pointed out, right? I get out of the car and I back up behind the car. That's more defensive than offensive. And that's what we talked about. You remember the testimony doesn't have to be offensive. MOUT training doesn't have to be aggressive, right? Learning how to enter a building doesn't have to be aggressive. If it was, why would Joe have to go teach me how to defend my house? Right? Someone's breaking into my house and I'm outside. How do I defend myself? Right? That's what they're looking for. So to continue to tell you this is all offensive, I'm sorry. I find that also a little disingenuous as to what's actually going on here. And again, I'm going to bring this up because I had it right here, even though I know you heard it. If the FBI tells Dan, you can do nothing illegal, but then they have Dan do the training, how can I sit here and tell you that the training was illegal? Catch-22, right? It doesn't, again, it doesn't pass the smell test. It doesn't work. Pieces don't fit together for you to make that immediate connection. I think you heard, and I'm only going to touch on this briefly, right? Vac Shack, no plan. Right? Back in June, there's a meeting. These guys go. I believe the testimony is that Dan smokes pot the not Dan, I'm sorry, I apologize. Adam smokes pot the entire time he's in that basement. And as he's talking and talking, there's no plan made. There's no plan identified. The only thing that's truly talked about from any of these guys is, again, the same thing Mr. Johnson brought up. Let's get a warrant. Let's effectuate an arrest. And not let's effectuate an arrest, but let's get a sheriff to do it. They even had a sheriff picked out, one that they thought would be on their side. And I would tell you, in today's day and age, that's not that far-fetched for some people. Again, not a bunch of legal scholars sitting here going, well, the logistics of this don't work because of this legal and this legal. And no, these are guys going, maybe this is how we solve the issue that we have. Maybe this is how we get to our issue being fixed. Second Amendment, right? Let's talk about that for just 1 second. It's as hot button a topic as there is in this country. And it's that way today, and in 2021, and in 2020, and in 2019, and in 2018, and probably back before 2016, right? There's no evidence that these guys are the mass terrorist school shooters. There's no evidence that these guys are going to go to Oklahoma City and blow up a building, right? To bring that in is, again, it serves one purpose, to inflame you and go, oh my God, that's what they're doing. And the FBI saved us. Well, saved you from what? Right? Saved you from a bunch of guys who are protesting? Saved you from a bunch of guys who are going, no, this is not what the Constitution says. This is what our rights are. Right? Pick a topic in America today. Second Amendment, abortion, any of these, right? And there are heated opinions on both sides. Are there people that are standing out there screaming? Sure there are. That's okay. That's the purpose of the First Amendment. Don't let this trample what that is. When you get down to it, you look at this rationally, logically, put it all together, string it together from front to back, chronologically, and ask yourself, how do you get from inception of this back in November all the way through to today? I can just sit back and go, yeah, there's reasonable doubt here, right? There's some things that we heard, but remember what reasonable doubt is. I talked about it earlier. Not only the evidence that you got, but it's the lack of evidence on something else. And there's plenty of lack. There's plenty of things that were insinuated, that were put out there, that were given to you in a specific light to fabricate how you think about these things, right? From what these guys were saying, partly, to Dan and his career, to his reimbursements, to the FBI, not knowing what's going on from one agent to the next. These are the things that take people and make them go, I don't know what's going on with the government, but this isn't what I expected. This isn't how it's supposed to work. And that's what drives 200 people, 300 people to go to the Capitol and stomp their feet. But you heard the lieutenant tell you, nobody broke any laws. You heard the lieutenant tell you, yep, I saw Joe Morrison. No issues, no problem. If I spin the tail and go, Dan kept them from storming the Capitol. They stormed. The lieutenant told you, the doors were open. They walked in. So ask yourself, why do we have to spin this tape? Why? Because it gets them on the book that Miss Dautamani wanted you to see. This chapter, this chapter, this chapter. Don't let that happen. It's disingenuous. And there's no basis for it, right? I can take any part of a story and spin it one way. I can take any part of a story and get you to see it this way, right? And that's what they're trying to give you, right? They're putting it back on us, saying we have no burden. But ask yourself this: if they're going to tell you the defense has no burden, how is it that they're going to sit here and tell you, well, we gave them the stuff, it's their job to show it to you? Doesn't that then give me that burden? Where if they would have just given us the whole picture to begin with, then we can make a decision. The jury instruction for material supported terrorism tells you, and Ms. Dautamani put it up here, and Mr. Johnson touched on it, and I have it here, right? Providing support means currency or financial securities or other financial services. Well, there's been no testimony that Joe provided any kind of finance whatsoever. Cross that off, right? Lodging. Nobody stayed at his house. He didn't say, hey, come pitch a tent in the backyard. Hey, put your trailer here. No lodging was provided. Training. Joe didn't train anybody. Right? Joe wasn't out looking to train anybody. Again, their witness, that chair, he did the training. Doesn't matter that it wasn't good training. Doesn't matter that it was training that they could have found on the internet. Who did the training? Dan's words, that chair, he did. It's a struggle, but he did. Safe house. No, never came up. No testimony of that. False documentation or identification. No testimony to that, right? Never been alleged. Communication equipment. No, Joe wasn't providing radios. He wasn't providing walkie-talkies. He wasn't providing anything along those lines. Facilities. The fact that Joe was having these trainings long before anything happened at his house and guys were coming over to shoot doesn't mean that the fact that the guy Dan vouched for, who came over and trained, that they had any knowledge of this is what was going on, right? That's the crux to this facility part of this. Did it happen on Joe's property? Yes, no argument. Did Joe know? No. Why? I already mentioned it to you. Adam told Dan, Joe doesn't know. If he did, he wouldn't be down for it. So facilities. He's not facilitating the act, right? He's not facilitating the act of terrorism, right? If you want to lump it in with the training, then make it part of the training, but it's its own separate thing. So he's not really providing a facility. Weapons, no testimony of that. Lethal substances, no testimony of that. Explosives, no testimony of that. Personnel. Commentary was made, and I believe, and I could be wrong, but I believe it was Mr. Wilson that asked the question to Dan. You don't have any magic powers, right, to make these guys do this. Dan said no. Well, ask yourself, what magic powers did Joe have, who couldn't even keep track of his, group, whose group was crickets on him, whose group was constantly complaining he wasn't involved? Well, how does that fit for Joe then? Right? It doesn't. There's no magic power for Joe to tell these guys, you got to go. Right? And he didn't. He didn't tell anybody to go do anything. In fact, I think the testimony, and Mr. Johnson pointed it out, that Adam Fox came and he cherry picked these guys. Oh, you're the one, you're the one, you're the one. You guys come with me and join my group. The rest of them fell by the wayside, to include Joe. So again, is he providing personnel? No. Adam came and took. Joe didn't provide anybody. He had no ability, no authority to order people around. Transportation? No. No evidence of that. Including physical assets and intangible property or expert services. Well, what expert services? What expertise did Joe provide? Nothing. Right? You heard it. Their witness, that chair. Dan did. Again, no entrapment here. But ask yourself, what's the credibility of this witness of all of this when we can't get the same answer twice in two different courts, or sometimes in the same court? Because some of this testimony took place here back in, previous hearings, or downstairs in the second district. There's too much here to relate this back and go, well, this is just a simple little case. Well, no, it's not. But I do think when you look at all these pieces together, right? When you look at what these guys were actually about, what they were actually talking about in its entirety, in context, the reasonable doubt is more than there. And I urge you to see that and return a not guilty verdict against Joe Morrison.
Patrick, I assume yours is going to be an hour or so.
45 minutes to an hour. I'm going to try and tighten it up. So
We take 10 minutes and we'll come back and listen. Be seated. Okay, Mr. Kirkpatrick, whenever you're ready.
Thank you, Your Honor.
Good afternoon, everyone. And we're down to one, finally. I too want to thank you. I always do. This has been a tough case, I think, for everybody as far as time-wise. I know that you've all been paying attention because I've watched you, I've caught you out of the corner of my eye repeatedly taking notes and paying attention and keeping an open mind, which is what I asked you to do in the beginning, and I want to thank you for that. Ms. Dalamati brought up an important point in her opening regarding if attorneys raise their voice. And so if I've raised my voice in this case to the point that it offended you, I apologize for that. But I guarantee you, when I go through this closing, I'll be able to point out each and every time that I raise my voice. And each and every time that I raise my voice is because I was frustrated and sickened. I've been doing this for a long time, ladies and gentlemen. And the bouncing around, the picking and choosing, the taking sound bites that match their case and causing me to have to fight tooth and nail to play things that should have been played caused me to be frustrated. For that, I do apologize, but I will point out each and every time when that happens. Ladies and gentlemen, I asked you all to promise me something in voir dire long ago. That promise I asked you was, listen, you're going to hear a lot of things that Mr. Beller said. You're going to hear a lot of things that were said by Mr. Beller. You're not going to like them. Ladies and gentlemen, I was a police officer. I was a Marine. I knew you weren't going to like him because I didn't like it. He's not here for terrorist threats, ladies and gentlemen. He's not. I've said that a million times, and that's a fact. What is he here for? He's here for material support, providing material support for an act of terrorism. He's not here because of statements he made in his vehicle. He's not here because of statements he made when he went to a QRF, or he went to the Home Depot parking lot, or he went to Detroit. That's not why he's here, ladies and gentlemen. He's here, and the charges are clear, and you will get this jury instruction. He is here for providing material support for an act of terrorism. First, that the defendant provided material support or resources to Adam Fox or Barry Croft. Second, that when the defendant provided material support to Adam Fox or Barry Croft, he knew that Adam Fox or Barry Croft would use that support for those resources, at least in part. All that stuff that you heard, ladies and gentlemen, from November, January, February, March, April, May, June, the first part of June, is a waste of time. It's an absolute waste of time. Here's why. Fox doesn't even come into this group, and not that he came into the group. Adam Fox is not even mentioned in this case till June 14th. Period. It's right here on the timeline, ladies and gentlemen. June 14th. And that's the training that takes place in Munich. Up to that point, facts and evidence. My client didn't know Adam Fox, hadn't spoken to Adam Fox. Well, when he was questioned, when Agent Impler was questioned, he may have seen Adam Fox at the April 30th protest at the Capitol, again, where no laws were broken. But up until June 14th, he had never met, spoken to, trained with, or did anything with Adam Fox or Barry Croft. Prior to that date, he, Mr. Beller, had broken no laws at any protest. That's facts and evidence, ladies and gentlemen. Agent Impler testified to that. Broken no laws at any protest, broken no laws at any of his QRFs that he went to, whether it be the Black Lives Matter protest or any other protest. In fact, to the contrary, two of those, we had not only one, an FBI agent, but also in the other one, a sergeant who watched them for 2 hours. Violations of the law, nothing. In fact, Agent Impler testified when Mr. Beller left the state of Michigan for good, July 27th. He was never arrested. He was never charged with any crimes. More importantly than that, the testimony is unequivocal. He did not commit any act of violence against any member of Michigan. He did not level a firearm on any police officer in the state of Michigan. He did not assault a police officer in the state of Michigan. He had committed no acts of violence in the state of Michigan when he left for good on July 27th. Now that's very, very, very important, ladies and gentlemen. And the reason being is the prosecution now wants to mold this argument. Oh, well, hey, They talked about doing this to police. They talked about doing that to police. They talked about doing this to politicians. Ladies and gentlemen, make no mistake about it. I implore you, when you go back in deliberation, I implore you to find me one other act of terrorism in this case that was not the plan or plot to kidnap Governor Whitmer. There isn't one. And that's very important. There is not one. There's been no other showing to you that Mr. Beller broke any laws at any of these other protests. There just isn't. It is the plot or plan to kidnap Governor Whitmer. So now we're at June 14th. There's a training on June 14th. Agent Ippola testifies and he says, well, you know, at that training or after that training, there was a phone call made to Adam Fox. What does he say first? Paul was there. That's his testimony. From the people who prepared him for this trial. Paul was there. He was there for that phone call. And there's a phone call later that night to Adam Fox. That's not by anyone here. It's actually by the FBI agents and Dan, who unbeknownst to my client is even going on. What happens when they come back for testimony again? The people. Agent Imple's up there. Agent Imple, remember yesterday when you testified that Paul wasn't present? This is the people doing this. That Paul was present during that first phone call to Adam Fox. Is that true? Nah, you know what? It's not true. Now that I think about it, he left early on June 14th. He wasn't present for that phone call. That's facts and evidence. He didn't know that that phone call had been made to Adam Fox. This is June 14th. The later call that night, when FBI handlers are sitting right next to Dan, making this phone call to Adam Fox, Paul's not there. There's discussions, they're animated, the testimony of the phone call, and Dan invites him to training on June 28th, or invites him to training immunity. Next up is a protest on June 18th at the Capitol. This is one that they didn't enter. Dan starts off by saying, we meet Adam at the Capitol. They're outside talking about this, that, and the other thing, and stuff, going at the Capitol, and Paul's right there. Paul's part of that conversation. What do I have to do? Which I'm going to be saying this a million times in this closing. I had to get to the transcripts. Hey, Dan, remember when you testified back at preliminary exam? Yeah. Paul was not engaged in those conversations. It was like pulling teeth, ladies and gentlemen. But that was the final testimony of Dan, that Paul was not involved in those conversations with Adam Fox at the Capitol on June 18th. That is facts and evidence that was testified to unequivocally. Nothing happens on the 18th of June. Nobody gets arrested. There's no issues. There's no problems. Next up is the Vac Shack. That's on June 20th. Vac Shack, I got it right this time. That's on June 20th. It's 2 days later. What are facts and evidence? Paul didn't set it up. That was testified to. Paul didn't make this plan to meet Adam Fox. That was testified to. And he was invited to go there by Dan. That was testified to. It's all facts and evidence. Paul goes to this meeting at the shop vac. And they get there. They go through, they open up a trap door. They go down his basement. Adam Fox is down there smoking pot. He's talking all kinds of gibberish. This is the first time I got angry, ladies and gentlemen. First time I raised my voice before this court, and you were in here for it. It was necessary. Here's why. Prosecuting attorney wanted to play for you a recording from the Vac Shack. Not the whole thing. A piece. And ladies and gentlemen, it's exhibit 125T. And I beg you, when you go back into deliberations, I beg you to look at this exhibit. Because this is all the people, wanted you to see and read in that meeting. What does it say? Mr. Beller, here's another thing, is that I feel like if we're going to be doing this, we should probably get the other states involved, not just like help us out, but unintelligible. More importantly, Paul goes on to say, what I'm trying to say is a dominoes effect. If Michigan is going to go and we're going to be taking our governor, I want to see more states do the same thing. It was a Friday. We were right here. I was right here. I stood up, objected. I didn't object to all of it. I objected to just this portion being played to you. I wanted all of it to be played. The 3 minutes before, remember the argument I had? Judge, 3 minutes. I'm just asking for 3 minutes. Play the 3 minutes leading right up to this statement. That's all I want, all I'm asking. They fought it. Then I had to stand up and I had to ask questions of Agent Impola. Well, Agent Impola, isn't it true that they were talking about getting an arrest warrant? Oh, they were talking about doing citizen's arrest. I don't know if it happened right before. I don't know if it happened afterwards. It happened sometime. But Agent Impola, isn't it true that the part of talking about getting an arrest warrant for the governor was said right before this? I don't know. Well, guess what? Comes back in again. Yeah, that's right. The conversation did happen right ahead of time. This is the FBI, ladies and gentlemen. This is the prosecuting attorney putting on this case, trying to convict my client. You would think that they would know the important facts of the case. And ladies and gentlemen, that's pretty important, because if I wasn't doing my job, I didn't take the time to listen to this, and if I didn't bring it to your attention, this is how it would have been presented to you. That's not the case. I fought for it. Then you heard it. And you heard it, and it was unequivocal. Well, we can get a right-wing judge, and we can get a conservative sheriff, and we can go get an arrest warrant for the governor for treason or for whatever wrongs we believe that the governor did. And if we use that peace officer and we go to the Capitol and the peace officer goes to enforce that arrest warrant, MSP officers have to honor that because it's an arrest warrant signed by a sitting judge. Ladies and gentlemen, how long did it take me to finally get Agent Impola to agree, I guess you're right, it wasn't a citizen's arrest? Because at first, even after we heard the audio, oh, it's a citizen's arrest. It's a citizen's arrest. Agent Impola, did you not hear them say they were actually going to get a peace officer? Did you not hear them say they were going to actually go to a judge and get a warrant? So if you go, and then I asked him, as a police officer, if a judge signs a warrant that says thou shalt arrest, thou shalt arrest. You can't stand in front of that. He finally acquiesced. Yeah, they were trying to get an actual arrest warrant to arrest the governor for what they believe wrongs to the state. Now, again, is that going to happen? I even said that when I was doing my cross-examination. I'm not naive here. I'm a lawyer. He's an FBI agent. I even said the judge is here. Is that really going to happen? No. But in their minds, they're not talking about kidnapping the governor. They're trying to figure out a way to do something legally. You know what disgusts me the most about that 20th? Mr. Adamati gets up in a redirect. Remember this? Agent Impola. They wanted to get a boog judge. They wanted to get a boog judge. Remember that, ladies and gentlemen? They didn't want to get a circuit judge. They didn't want to get a district judge. They didn't want to get a court of claims judge. They wanted to get a boog judge. What's Agent Impola say? Hey, you're right. That's what they wanted. They wanted a boog judge. So I had to play the audio yet again. Agent Impola, where do you hear boog judge in here? Well, there's something in there that's unintelligible, and it kind of sounds like. What's his final answer? They didn't say it. They didn't say boog judge. This is the prosecuting attorney. Then, after that, we get to this part. You probably remember this too. Agent Impola, did Paul ever tell Dan the informant that Adam was crazy? She even did the hands. Crazy. What's his response? Nope. Instead of that, In fact, they didn't even leave together from the shop. Paul left early. So he couldn't have said it, right? Couldn't have said it. What happens? Either after break or the next morning, whenever, what happens? Here comes Agent Impel again, sitting back down. Here comes the prosecutor again. Agent Impel, do you recall when I asked you if Paul had left early from the shop vac or from the vac shack? From the vac shack? Yeah. And you said that he had left early and that they didn't actually leave together, correct? That's true. Was that true? No, they left together. They left at the same time, fixing his testimony yet again. Were you able to hear whether or not Paul said Adam Fox is crazy? No, pant noise. He said that, pant noise. Couldn't hear it. So I guess we should rely upon what Dan heard, what the informant Dan heard. He agreed with that. Then I asked him, Ms. Dadamonte asked you under direct examination, did Paul ever say that Adam was crazy? Your answer was no, right? Yeah, didn't say it. Okay. Go to the transcripts again. Again. How many times I go to transcripts? We're going to get there. It's a lot. Go to this page, go to this line. I don't know how many times, I'm paraphrasing, ladies and gentlemen. I don't know how many times he did say he was crazy. I don't know how many times he said he was crazy, but it was more than once. I had to get that out of him because I read these transcripts over and over and over again. Then what does Miss Dadamonte do when she gets back up on redirect? Well, did he say he was crazy? No, he said he was Leroy Jenkins. And then we get into some sideshow about some video game about somebody standing outside going to go through the door. I don't even know what it was. I don't even know what the video game was. I kind of tuned it out. Because then I went back to the transcripts again. Show me anywhere in the transcripts where you said Leroy Jenkins. Didn't. Yes, got loud there. And they come back saying, we're still at the back shack. They come back after my cross, after I bring all this stuff out. And they're digging. Oh, they're digging. And they get exhibit 279, 280, and 281. Because, ladies and gentlemen, what they want to show you is Paul's the big bad wolf. And so look at all these bad things that Mr. Fox said still at this back shack meeting. Look at all these bad things he said. Look at what Ty Garvin said. Look what he said here with Dan and everybody else. Feller. Yeah. That's it. Yeah. And when you listen to that, it's not even a part of the conversation. It's just a yeah. Why? Put the case together. Next up is June 28th, training and unit. Now, from June 20th to June 28th, there is no communication between Mr. Beller and Adam Fox. Zero. Some facts and evidence to support it. There is none. None. Adam Fox is described as a VIP coming to training. That's what he's described as. That's testimony, that's facts and evidence. He was described as a VIP coming to training. Now, there was conversation with Adam Fox between June 20th and June 28th. Wasn't with Mr. Beller. It was with informant Dan communicating even further with Adam Fox because we got to get him there on the 28th. That's fact. 28th rolls around. Training. Under direct. Prosecution asked Agent Impel. So before this training, there's a circle up. Get together. Adam Fox, Pete, everyone else, and there's discussions about kidnap the governor, political violence, things along those lines. Agent Impel testified that that happened before that training. That's really important, ladies and gentlemen. It's very important because June 28th is the first time that my client ever trains with Adam Fox, period. So it's important for people to portray to you that this conversation took place before the training and you didn't leave. Not only am I going to show what, let me finish on with this. So I asked him, was it after? So Dan gets on the stand to testify. Remember, this isn't recorded. We got OPSEC at the shop vac. There's phones going and canisters at the shop vac. That's recorded. There's supposed OPSEC going on all over the place. But June 28th is the one time where we don't have any audio of the training. You give that which way you believe is appropriate. But Dan gets up and I said, so Dan, after the training, you guys had this circle up, and that's when Adam Fox talked about kidnapping and political violence. And Dan says, well, I don't recall if it was before or it was after. And then I said again, well, it was after. Mr. Ralston stands up. Well, wait a minute. He says he's not sure if it happened before the training or after the training. What I say, let's clear that up. Went right back to the transcript again. Guess what? Happened after the training. And that's important because Ms. Dadamani just stood here in her closing on that very training and said that that conversation took place before the training. And then even put on her little slideshow up there that he must have been down basically because he didn't leave. That's just not the case. He didn't know about this. He didn't hear these conversations until this training was over. And it was a training that basically said you're either down or you're not. And this is what we're about. It's June 28th. What happens? Paul, gone. Facts and evidence. Now listen, we can argue he was mad because his girlfriend couldn't train with the group. We could argue that he had a disagreement, whatever the case may be. We could also argue that he realizes, you know what? I don't want to be a part of this. I'm going to start my own group. So after that training, he's done with the Wolverine Watchmen forever. The next day, Dan, to his FBI handler, Doc's leaving the group. Remember those text messages? Doc's leaving the group. Does he say, hey, let's let him fly. Let's see where this goes. Let's see if, what it is that he's trying to do when he leaves the group. No. Get him with Adam. That's what Dan says to his handler. Get him with Adam. Does the handler say, no, we're not supposed to entice, we're not supposed to encourage, we're not supposed to bring people together. Don't do that. Let's just see where he goes. Good idea. That's what the FBI agent says right to Dan. Dan does what he says he wanted to do. He goes to the meeting at Paul's house on July 7th. Paul's house on July 7th, where this ghost group, this shadow group, this QRF. Ladies and gentlemen, I was laying in bed last night and I'm like, quick reactionary force. About this for me. Quick reactionary force. What does reactionary mean? Quick reactionary. We are reacting to something. It's not quick attack force. It's not quick strike force. It's not quick offensive force. It's quick reactionary force. Now, how do we know that that is true? Because yet again, I had to get into the transcripts and I had to get into the audios for this get together on July 7th at Paul's house. Bottom line is this: on July 7th, at his home, Paul says, and I quote, mission statement of the group I'm trying to create right now. I am not an aggressor. This will not be an aggressive group. He goes on to further say, we're about defending. We're not offensive or defensive. We're going to train in case we have to protect ourselves or somebody else. We're not about effing black bagging politicians. He makes that abundantly clear. This is what my group is about. I've left that group. I'm creating this group. And yet again, does Dan say, wow, take a step back here. See what my, come on. You can't do that. Well, Wisconsin, you heard it. Wisconsin, it's going to be some heavy hitters there. He knows the heavy hitters that are going to be there because he's being briefed by the FBI. He knows who's been at the meetings in Ohio. He knows all the players in this. Paul doesn't. He does. Keep an open mind. Training's going to be offensive. Then he testifies. And I get that out of him across. What does people do? What do you mean by keep an open mind? Oh, well, there might be some drug usage in Wisconsin or a belt-fed machine gun. That's the excuse. That's the explanation given to keep an open mind. Ladies and gentlemen, you're smarter than that. I know you are. You're just smarter. keeping the open mind is, hey, look, what you just said about being defensive and not offensive and not being the aggressor and basically not black bagging politicians is dead on. No, that doesn't fit the agenda. Next up, Wisconsin. Asked. Yep, yeah, I get you there. No. I might have bought him a meal, might have driven him there. You heard the testimony of Dan. Took me a minute, had to go back to the transcripts again. Had to have to read them again. You heard what he said. Paul wasn't going to do that. Ladies and gentlemen, I'm gonna throw something in here right now. This whole entrapment thing, which I'm gonna argue again in the end. I think now's a good point to point this out. You haven't heard me one time in this case say entrapment from beginning to end. And here's part of the reason why. In order for you to have entrapment, ladies and gentlemen, you got to break the law. You don't break the law, there's no entrapment. What are you being entrapped into doing? You can't be entrapped into being a non-lawbreaker. It presupposes that a law was broken in here. There's been no laws broken. When I talk about the things that the FBI did through their informant, when I talk about the things that Dan did, I'm talking about Paul's state of mind. What is in his mind going on? And how is that being affected by the maneuvers that are being done here by Dan and his handler? That's what I'm talking about. So we get to Wisconsin. Paul is there for training. Now, Paul doesn't put this training on in Wisconsin. It's put on by the Wisconsin 3%. Adam Fox is a Michigan 3%. Adam Fox, the testimony undisputed is that this was Adam Fox's show. This wasn't Mr. Beller's show. It was Adam Fox's show. He was the one running things with the Wisconsin 3%. The same group on June 28th that Mr. Fox asked Mr. Beller to swear allegiance to on June 28th, Mr. Beller said no. And in fact, that's when he left. He didn't want to be a part of Adam's group. Then, two people. Start off with Dan, foreman for the FBI. Gets up there. Oh, yeah, Paul was doing all the medical. Yeah. Battlefield medical, tourniquets, plugging holes, doing this, that, and the other thing. Oh, yeah, that's what happened. I got to get the transcripts out again with Dan. Again. Because Dan testified at exam. He didn't go through the medical training. He didn't go through Paul's medical boot that he supposedly had up. He has no idea who Paul trained. And he has no idea what Paul trained. But see, it's important, ladies and gentlemen, because we got to get some kind of training here. Adam Fox is around. We've got to get it. Because that's who he is alleged to have materially supported. Then we get undercover agent Mark. Undercover agent with Federal Bureau of Investigations comes in here and testifies because he was there that one day in Wisconsin. What does he say? There was some, basic training going on. There was some tactical training going on. Was there medical training? Oh yeah, medical training. Who did that medical training? Oh, Paul Beller. Paul Beller did that training. Battlefield training, tourniquets, this, that, and the other thing. What I have to do, again, with another witness. Can you please go to your exam transcripts, which, by the way, just happened back on September 1st, a mere 7 weeks ago. This case is already rocking and rolling. What does he testify at the exam? I don't know who put on the medical. So we know that he knew about the Wolverine Watchman when he went to Wisconsin because he's an undercover. And I asked him, I was specific about it. You know who your players are. You knew about the Wolverine Watchman. You knew who was going to be president of Wisconsin. He knew who Mr. Beller was when he went to Wisconsin. He knew that. And yet he doesn't know who did the medical training until he comes in to testify in this case. And then what happens again? Ms. Dodamani stands up again. Mark, that was a different case, right? That didn't deal with these defendants. That was a different case. Didn't deal with Mr. Beller. It dealt with this whole case, ladies and gentlemen. That's what it dealt with. And he knew when he testified on September 1st, he didn't know who did the medical treatment. Then he comes in here to try to say that he does. It's wrong on every level. Then, during this training, there's a dinner. Barry Croft, this is the first time that Mr. Beller ever met Barry Croft. There is zero facts and evidence that Mr. Beller trained Barry Croft at Wisconsin. Zero. There's a dinner. Paul goes to that dinner. Informant Dan goes to that dinner. Barry Croft goes to that dinner. Adam Fox goes to that dinner. There's some other people at that dinner. What do we know about that dinner? Paul's eating and drinking. Took me a minute to get there too. Had to get the transcripts out yet again with Dan. But the final testimony was that, excuse me, Paul didn't contribute to the conversations. Paul didn't go outside when they had conversations. Recall me getting that out of him as well? They went outside. They were talking about weapons of mass destruction. They were talking about kicking off the boob. They were talking about X, Y, and Z. Paul's still inside the restaurant, drinking and eating. He leaves. Next day, they're gone. They leave Wisconsin. He didn't set any of that up. Ladies and gentlemen, what I'm about to show you, in my opinion, is the most important piece of evidence in this case that pertains to Mr. Beller. It's funny how little things can jump out at you, and it's like, wow, that first glance, it doesn't make much sense. But then you look at it and it just jumps right out at you. It's Exhibit 164. Exhibit 164. It is a Facebook message. It is a Facebook message between my client, Beller, and Adam Fox. This is the Facebook message that the people talked about when Paul says he reached out to Adam when he created this ghost group on July 7th. This is the message. The message starts off, "Hey, sir, Doc," parentheses, ex-admin of the Wolverine Watchman. He doesn't say, "Hey, buddy," "Hey, pal," "Hey, friend," "Hey, comrade." Hey, he says, "Hey, sir." It's Doc. Then he's got to explain to him who Doc is, because Adam Fox doesn't know him from Adam. Doesn't know him at all. Just says, "Just so you know, I'm still part of the movement. I had a disagreement on certain ways the group I was with was going. So I had made the decision to take my leave and start my own group. I have no bad blood with the Watchmen or the head of the group, just personal preferences." Now, I'm going to get to you here in a second why this is very important, I believe. This is what the prosecutor wants you to see, and they've done it throughout this entire trial. The black box, that's what they want you to focus on. Not me, I look at everything. July 13th. This is a day after they leave Wisconsin. This is the last communication that Mr. Beller ever has with Barry Croft or Adam Fox. That's it right there. July 13th, title, Dan Abbott, Van Buren County Sheriff. Right down below, author Paul, sending to Adam Fox. There's the sheriff that we should have someone reach out to. Adam Fox's response, "Yes, sir. I'm getting on it this week." Ladies and gentlemen, this is July 13th. This is the day after they left Wisconsin. There's nothing in here about great training, Adam. Great training with you and Barry Croft. Great ideas about political violence. Great ideas about kidnapping the governor. Great ideas about let's work on this and let's move forward. And man, I really want to go out and hurt people. Ha, none of that. Dan Abbott, Van Buren County Sheriff. There's the sheriff that we should have someone reach out to. Because in his mind, ladies and gentlemen, he's all the way back to the shop vac. All the way back, back shack. Back shack. Where the discussion is arrest warrant and getting a sheriff. Not kidnapping anyone. And ladies and gentlemen, Exhibit 164, that is it. That is it. Adam Fox, Barry Croft, this pertains to my client. There's a training on July 26th. My client goes to it. There's no training specific to kidnapping the governor. There's no training specific to anything. And oh, by the way, Adam Fox doesn't go, Barry Croft doesn't go, Pete doesn't go, Joe doesn't go. I'm tired of beating a dead horse here, but I think anybody with any common sense or any experience at all with that PT Cruiser knows that is not offensive training. That was defensive training. Now we've got July 27th. Oh, yeah. Remember the big deal the prosecutor made out of the code words? Ooh. Paul made these code words: OPSEC, s'more, bonfire, SpaghettiOs, destroy after reading. What was the testimony of Agent Impola? They were hardly even used. I think he might have testified they were used one time regarding bonfire, and there actually was a bonfire. No testimony that those were used by Adam Fox, Barry Croft, this group that decided to go up north to go after the governor. Zero. Yet again, it's like that old saying, let's take what all we got, let's throw it to the wall, let's see what sticks. That's what's going on here. July 27th, I'm out of here. Hey guys, I'm leaving. I'm going to go back South Carolina. I'm going to move in with my dad, stack up some cash. I'm going to go back to school. I'm going to get my EMT. I'm going to get a job as a firefighter. That's his mindset. And you know, the other thing that's funny about trials is things will jump out at you when there's testimony. And it jumped out at me when the landlord came in and testified. I've never spoken to her. Quite frankly, I didn't really even, in all honesty, I didn't really look at what her testimony may be. But you know what she said that jumped out at me more than anything? Is she said, Paul left voluntarily. She testified, Paul left voluntarily. Paul was not evicted. He left voluntarily. And then I got to thinking about it. I said, you're right. Governor Whitmer had issued an executive order, moratorium on evictions. So do the federals. You couldn't evict somebody if you wanted to. He could have hung into that apartment like a tick and not paid a nickel if this is really what he wanted to do. If this is really what he wanted to do, if he really wanted to be a part of this group, if he really wanted to go with Adam, Barry Croft, go up north and do all these things, he could have done it. He didn't. He left. What else happened on July 27th? On the other side of the state, Grand Rapids. We know what happened. Dan had a taco dinner with Adam Fox, facts and evidence. They went back to the back shack, just the two of them, Dan, informant Dan, and Adam Fox. And Adam Fox decides, I'm going to change, now going after the Capitol. Now I'm going to go out, I want to go after the governor. July 27th. Paul's not there. In fact, Paul's never been anywhere with Adam Fox after Cambria. Not only does Adam say he's going to change the goal here, we got to start a new chat. We got to start a new chat because we're not in the bonfire, which is the chat that Mr. Beller had. And pardon my language, this is the fuck around, find out chat. Here's where I yelled again, ladies and gentlemen. And again, for that, I apologize. I yelled. I was frustrated, very frustrated. Because yet again, this is what the prosecutor, Exhibit 177. This is what the prosecutor wanted you to see. This is all that they wanted you to see. Again, we've got a black box up here, doc, administrator, and down here we've got a black box that says from Denzi, Denzi, which we know is Adam Fox, says, okay, well, how's everyone feel about kidnapping? Not kids, high-profile scum. Show this to you. We show this to you to try to keep this connection together between Adam Fox and my client. That's why they showed this to you. Because without that, there is no case. But is this even true? It's not. Remember what I had to do? I I had to go get 15 pages. Remember, we counted them out right up there. We counted them right up there. First thing I had to do is Agent Impola, do me a favor. Go to this fuck around, find out chat and tell me what page this here starts on.
Page 2.
Okay? Do me another favor. Go through all those, that message thread. Go through that entire message thread. You show me one time where Mr. Beller communicates with Adam Fox. Well, there isn't one in here, but there's a whole lot of this. There's a whole lot of these messages. I don't know. Mr. Beller's on trial. That's when I yelled. Remember? He's on trial. I was angry. You're going to come in front of this court, in front of you, throw this at you to keep that contact together with Adam Fox and Mr. Beller, and you can't show one message where he actually even was a part of this group. The informant set this up. The informant set up his administrators. And Doc, Mr. Beller, was never involved in it. And we also know on July 27th, he's gone for good. That's been the testimony of everybody. That's about the only testimony that's been clear and unequivocal. Yeah, Paul leaves, doesn't come back. He's not in any trainings. Not in August, not in September, not in October. He's not in Luther, he's not up north, he's nowhere. Then comes the infamous warning from Paul. Ladies and gentlemen, first of all, as you know, with this message, it never went to Adam Fox. It never went to Barry Croft. It never went to Pete. It never went to Joe. This little warning, this little message, this little, hey, the police were snooping around the house, it went to the group that he created on July 7th that was defensive, not offensive, that was they're not going to be blackbagging politicians. That's who it went to. What do they do yet again? People, let's block it out. Let's put these blocks around all this stuff. Yeah, black box, put the black box around that, put a black box around that. Those three things, sure. Let's don't put a black box towards the end where Doc says exactly, we haven't done anything illegal or wrong. They're probably just pissed because we're not open to the public like the rest of the cliche militias around. They're just sniffing their nose around most likely. Ladies and gentlemen, this is August 20th. He has no idea what's going on back in the state of Michigan. Because what do we know for a fact? When he left, there's no plan or plot to kidnap the governor. Zero. Isn't one. That's facts and evidence. That didn't even really start gaining some ground until August and really didn't become pursuant to the FBI agent's own testimony real until Luther, which is September. He's not here. He's not here for any of it. None of it. He has no idea what's going on back here. His mind is thinking, we said a lot of crazy stuff, which they did. We put a lot of crazy stuff on a wire, which he did. I said a lot of crazy things here and there, which he did. But he's not being charged with any of that stuff. None of it. They bring up, and I promise you, I'm almost done, ladies and gentlemen, and I appreciate your patience. They also bring up his warning, or not his warning, his reach out to his sister, Lizzie, regarding, if the cops question you. But here's the thing. I'm not an English major by no means. But this is what it says. Cops question my old roommate about me and some movements I was in. Well, and that's Exhibit 188. I was in. That's past tense. It further solidifies everything I've said up to this point. They show you pictures, Exhibit 99. Sorry, it's not color. Barry Croft and Adam Fox with their 3% sign. Do they have one of these with Paul? No. Paul is not a part of Adam's group. Paul's not a part of Barry Croft's group. And Paul didn't want to be a part of either of their groups. You also saw this timeline about communication on Facebook and this, that, and the other thing between the parties. They have one of those for Paul? Nope. There isn't one. Because Paul didn't communicate with them. Otherwise, it had been plastered all over. You've seen that a million times. Oh, the other thing, just a couple little tidbits here. They play a video. This got me upset too. They play a video of Paul training. That was Agent Impala's testimony. This is Paul training. Shooting somebody in the chest twice and in the face. Looks terrible. Looks aggressive. It looks barbaric. It looks like you're going to go out and kill the world. Does he tell you it was from a CPL course? A legal CPL course taken in this state to get his certificate. No, he doesn't tell you that. Why? Why would he tell you that? Come on. We got to make Paul look out to be a bad guy. Tell you it's from a CPL course? No way. That's what it was, ladies and gentlemen. CPL course. Ladies and gentlemen, in order for the prosecuting attorney to prove this case beyond a reasonable doubt, they have to prove beyond a reasonable doubt, first, that the defendant, Mr. Beller, provided material support or resources to Adam Fox or Barry Croft. They explain what material support is. Ladies and gentlemen, I'm not going to insult your intelligence. Material means what it says. Material. Kind of like if you're building something, you got to have materials to put something together. It's not one time. It's not maybe two times of being at the same training session together. It's material. The prosecutor, I chuckled inside a little bit when she said, ladies and gentlemen, do you see in here where, it says it's got to be more than one time? No. It should be common sense to any and every one in here that material means exactly what it says. Material. There's got to be some materiality to it. There isn't here. There's nothing. There's no showing whatsoever that anything that he provided was material. They talked about him training medical. They can't give you specifics on what was actually trained. They can't give you specifics on whether or not Adam Fox or Adam Fox even knew anything. And more importantly than that, remember Eric Molitor? Remember that name? That was somebody that was with Adam Fox from at least the Vac Shack meeting on, who was his personal medic. He didn't even need a medic. He never trained, Mr. Beller never trained with Eric Molitor. No need for it. They have to show that he materially supported Adam Fox, Barry Croft with training, which is really the only one that would apply here for Mr. Beller. They can't do it. They can't. They fail to do that. Because secondly, they have to, that when the defendant provided material support, and this is important, ladies and gentlemen, that when the defendant provided material support to Adam Fox or Barry Croft, he knew that Adam Fox or Barry Croft would use that support or those resources, at least in part, to plan, prepare, carry out, facilitate the terrorist act, the kidnapping of the governor. Unequivocally, we know on July 13th, when Mr. Beller speaks to Adam Fox for the last time ever, here's that sheriff. Go get that legal arrest warrant. This is after he's left the Watchman. This is after he's left the group. He has no idea. I promise you, give me like 3 more minutes. I'm right at the end. I almost forgot this. I also got upset. It took me a minute to get out of Dan, Ty Garbin, Dan Harris. You plucked them. You took them. Oh no, that's Paul's group. How's it Paul's group? Paul's gone. How's that possible? He ultimately, after getting the transcripts out again, admits, yeah, I took these guys. These are the guys that Paul or that Adam, saw from Wisconsin who were down, and I took them. So Dan takes from the Ghost Group created on July 7th, whose mission statement is defensive, not offensive, not to be the aggressor. Paul's gone. Let me take a couple guys here. Here you go, Adam. Now he's on the hook for personnel? I don't think so. Because that's not why he had his group. He did not know any of this was going to happen. And there's zero evidence that the people can support the fact that he knew any of this stuff with the governor was going to happen. I see what they're doing with the whole, well, act of terrorism doesn't necessarily mean the kidnapping of the governor, political violence. Act of terrorism could pretty much mean anything. And all that stuff that we spent 4 days on, throwing stuff at the wall to see what would stick or not, all the things that happened in March and April and May, before Barry Croft and Adam Fox even became a thing, well, it could be that too. Give me a break. Why are they saying that to you? I'll tell you why they're saying that to you. Because they can't get there. They cannot get there with this plot that they claim is the terrorist act in this case, and that is the kidnapping of the governor. Ladies and gentlemen, when you find, and quite frankly, I think I've proven beyond a reasonable doubt that he didn't do it. And I don't have to prove anything. If you don't have material support, the terrorist act, you got no gang. It's kind of bad English there. You don't have a gang. You just don't. Because a gang requires a couple things. First of all, a gang requires to prove that a group of persons was a gang, the prosecutor must prove that it was a group of 5 or more persons who had a continuing relationship with each other. Continuing. Paul didn't. Paul's gone. Paul's out of here. Paul's not a part of any of this. And you had to break the law. Which again, there is no material support of the terrorist act based upon everything that I've just told you. The felony firearm, that rises and falls with the case itself. If you think that they committed a felony and they're armed with a firearm, that's felony firearm. In this case, there is no material support of a terrorist act. Therefore, there is no gang membership felony. Therefore, there is no felony firearm. It really is that simple, ladies and gentlemen. It really is. I am confident that when you go back into the deliberation room and you look at these exhibits and you listen to everything and you talk amongst yourself, everything I told you in my opening, ladies and gentlemen, everything that I told you in my opening statement, I proved to you in this case. Everything. My closing was the same as my opening. It's been presented to you. And the other thing too, I think you're going to find is that when you discuss this case, the only common denominator in this entire case, the only common denominator is Dan. And that is unequivocal. Dan bounced from Watchman to this Ghost Group, to then leaving the Watchman the end of July, first part of August, to then going with Adam, plucking some guys with him, taking him here, throwing him up there. Now he's up north. He's doing the surveillance. He's in this game from the beginning all the way to the end. Ladies and gentlemen, I'm asking you to find that the prosecuting attorney has not met their burden of proof beyond a reasonable doubt that Mr. Beller committed any crimes. And I'm asking you to come back with a verdict of not guilty for materially supporting a terrorist act, gang membership felonies, and felony firearm. And remember, the other thing too is that each one of you are going to get another jury instruction. And I promise I'm done. It's the last thing I'm going to tell you. And by no means does this mean that I feel one way or another about this case, but I have to remind you too that you weigh the evidence against each defendant individually. Okay. So each one, and you promised me you would do that as well. You look at the evidence, because some evidence pertains to Mr. Beller, doesn't pertain to Pete and Joe. Some evidence pertains to Pete and Joe, doesn't pertain to Mr. Beller. And so I want to make sure that we all are still going to keep that promise, that you're going to weigh the evidence as it pertains to each and every defendant, and you're going to render a fair verdict, which I know you will. There's no question in my mind. I've kept your attention now for the last hour and you haven't fallen asleep on me, so I appreciate that. And I'm confident you're gonna come back with that. Thank you.
Okay. We still have to finish up jury instructions for you, given that it's 10 to 4. I see no point in having you stay and going into, and if I had you stay, we'd be at 6 or who knows what time. So I'm gonna send you home for the night. and We'll start back up at 9 o'clock.
John, may we approach briefly? I'm sorry, I didn't mean to.
We're not gonna finish the. What? He's good. No, I'm talking about him finishing his tomorrow,
Gotcha.
but I assume it's gonna be lengthy. And I know jury instructions have gotta be argued. That's what I was pointing.
And I apologize for even saying anything to the court, Your Honor.
No, that's if I missed something, I'd happily take the hint. But anyway, for the night, I'm gonna dismiss you and we'll take everything up by that point. We'll be ready to hear from the prosecution for the rebuttal. And we'll have jury instructions ready. And needless to say, my secretary is not very happy with me because she's canceling all kinds of hearings that we had set for tomorrow.
I'm doing
Oh, you're doing
them. I'm
okay.
doing them.
Ouch.
I don't care.
But anyway, we'll see you tomorrow at 9 o'clock.
All rise for the jury.
It's on Zoom still.
Are they still there?
Yeah.
Uh, 5-2 is, which ones do you have the objections to? Before I start going through the ones I already got.
Mr. Johnson's submissions and this is what you hear, is 5.8 character evidence of the defendant.
Right,
8.1 aiding and abetting.
yeah.
8.3 separate crimes in the scope of an unlawful, common unlawful enterprise.
Hold on, I don't have an 8.3 here.
Yeah, I think that, I took that one out.
Oh, okay. So I've got 5.2, 5.8A, 8.1, 8.4, 8.4, 8.5.
I did not have any opposition to 8.5.
And what about the other ones?
I oppose all the ones you've cited so far. as well as-
Character evidence, the 8.1 and the 8.4.
Yes, sir. That's character evidence is 5.8A.
Response? We'll do
And I
them
think
one at
we've
a
heard
time.
plenty of testimony from their questioning about bad conduct and memes and all this stuff that they put in the evidence, that the only other reason is the character of the defendant, that they hated the governor, that they hated law enforcement, they hated government. I think that the instruction is appropriate.
I think 5.8 actually cuts in the opposite direction. It presumes that evidence of good character, lawfulness, or peacefulness was presented, which is not the case.
Yeah, that's been presented too, when they, the testimony about the QRS, that nobody committed any crimes. The testimony about the protests at the Capitol, people going there and obeying all orders and not committing any crimes, being law abiding.
Hold on, let me double check.
Provide the court a copy of the instruction.
This we want to do.
I've got 5.8A, but I don't have the, you said 5.8?
5.8A.
Yeah, I've got that one here.
Okay.
But you were mentioning something else.
Do you want to take them one at a time?
Yes, one
Okay,
at a time.
that's my statement regarding 5.8A. Is that it's, you've heard evidence about the defendant's character for being law abiding. You may consider this evidence, and it goes on to say what it says. It is, that's an instruction that's used when evidence is submitted, usually in the line of self-defense, peacefulness, law abiding, those kind of character traits under 5.0 or 405 rather. And Michigan Rule of Evidence 405A is the controlling section.
Anybody else have a response to 5.8A? Character evidence regarding conduct of the defendant, you,
I have no comment, Your Honor.
My comment would mirror Mr. Johnson's. I think that we've heard ample testimony, both sides on character, so. And it was raised in opening testimony and then closing.
hmm, 5.8A is not coming in.
The next one, Judge, would be 8.1 aiding and abetting. Essentially, again, I asked the court to look at MCL 767.39. That's the aider and abetter statute. There's no evidence submitted that Mr. Musico was an aider and abetter in this situation. Our theory's consistently been that Mr. Musico was a principal actor.
Any response?
I don't have a
Anything?
I don't have on this one, Your Honor.
I don't think this fits this case. I'm not letting 8-1 in.
8.3 is a separate crime within the scope of common unlawful enterprise.
Hold on. That you just gave. I don't. Okay. It'd be easier if I gave each of you a packet because I don't have 8.3 in here either. Corey, can you make 5 copies? Corey?
Yeah.
Oh,
If they object to that one, I'll take that one out. That's, we need a copy. We can move on to the next.
okay. Inducement 8.4.
Generally, for use, when we're talking about aiding and abetting, it does not matter how much help, advice, or encouragement the defendant gave. However, you must decide whether the defendant intended to help another commit the crime. 8.4 is generally paired with 8.1, which is aiding and abetting. Any response?
Yeah, they've argued, I think the exact words were that my client was somehow joined at the hip with the musical. If their argument is gonna be that he was the principal actor only, and they're not gonna argue in rebuttal that he somehow helped, he was only principal actor, then, the court can make his rule.
Well, even in closing arguments, I think it's been argued repeatedly to look at each one as an individual and their actions and evaluating the 3 charges against them. 8.4 is not coming in.
8.5 was next on Mr. Johnson's list, and I don't have any opposition to that, Judge. It's in your presence.
8.5 will come in, I'll insert it in a minute. 10.3,
This instruction is intended for use when a conspiracy has been charged, Judge. And giving this instruction would be essentially adding uncharged conduct or burden of proof. So we're opposing that.
The vast majority of cases allege co-conspirator statements. And this instruction comes from the organized crime section, which includes gang related felonies, Your Honor. They've argued that this is a group, they've argued that this is a conspiracy, though they haven't charged conspiracy, they've argued that co-conspirator statements have come in. I think it's fair for the jury to have to determine that Mr. Musical not only agreed to join a gang, but agreed to be part of this underlying conspiracy.
I would agree with Mr. Johnson on his argument, Your Honor.
Does the court have a copy there?
yeah, I'm looking at it right now. Go ahead.
I was just gonna read it if you didn't have a copy.
Your reason for not wanting this in was what?
This is, this instruction is typically 10.3 for situations involving when a conspiracy has been charged. And what this does essentially, Judge, is, it adds the requirement that we show a conspiracy here to our burden of proof.
No, it doesn't. The court is going to give the elements. What it does, it defines conspiracy for these co-conspirator statements and show what needs to be proved. The court is going to give a separate instruction with the elements, but they're putting in these alleged co-conspirator statements. They're alleging, underlying that there's been this conspiracy that existed from the inception of this training group, William Washburn, to the takedown. I think the instruction is fair to be given, y'all.
The, what I think Mr. Johnson's done there, Judge, he's completed a legal ruling of these statements are both relevant and admissible as co-conspirator statements. There is no need for the jury to find also, as the court did, that these are co-conspirator statements. I mean, the jury's not being tasked with that, objective. I mean, he's trying to blend the pretrial motion with the jury's responsibility is here, and the jury's not receiving any instruction on co-conspirator statements.
Well, the very first sentence does, if there was a conspiracy, you must decide whether the defendant was a member of it. You may only consider what the defendant did and said during the time the conspiracy took place. It's not coming in. 10.5.
Again, for the same reason as 10.3, as well as the 10.4 I show is being requested too.
Yeah, I think took that one out as well.
Okay.
Okay, so we're down to 10.5. Again, 10.5 comes out of essentially the conspiracy chapter of the jury instructions, and it would be paired with 10.3 if you had a more defendant case with a charged conspiracy.
Yeah, it goes right along with the last one. It's not coming in. Okay, I'm gonna give you each a packet. See something, first thing in the morning, let me know. And deal with whatever issues you may have. That goes from the placement of the different instructions. As we get those, we can wrap up.
For like $1 million tomorrow. World. I gotta move my calendar around tomorrow too.
Usually
Oh, wow.
December is a slow month,
Yeah,
not gonna be anymore.
No, and Your Honor, I'm sure this is a formality, but we have no issues with Mr. Morrison continuing to Zoom as long as he's quarantined.
I think both of them should probably, I assume you want for the jury instruction or tomorrow, and their rebuttal or their.
Only question we need to address is what happens if there's a verdict tomorrow?
Correct. Tomorrow, or, I mean, I think his,
We worry about
Ex-
tomorrow first, and then.
Yeah.
if it
Let's
goes-
wait and see if we get a verdict and if necessary. I'll be surprised if they get back here that quick.
I think his quarantine is till Thursday, but I can verify and find out.
Not gonna happen tomorrow.
Huh?
I don't think it's gonna happen tomorrow.
I don't either.
I think so.
Do you? The optimist. Usually they'll either, if they don't have a verdict tomorrow, it's gonna be a number of days.
The middle of sentencing is when I got inmates.
Patience.
That's always how it happened.
You know,
I'll say that.
last time.
I feel cursed
The
having to shoot
last
up
two
with this.
times
Remember
we
that stupid
had
ass,
longer,
streaming thing? It's
like it
like
took them longer. It was
Colors
literally
and
both
colors.
times right in the middle of
I
sentencing.
keep getting that little, I quit watching.
Do you guys see the Buckeyes are still undefeated?
Or it'd be like the time Kareem did a CS
Oh, yeah.
in here with Judge Grant, and it took them 23 minutes the time they left.
Yes.
The time they brought them.
Ain't nobody's gonna watch me, except Pete and Chuck.
Yeah, I can't stand that streaming.
I wonder if they're regretting buying into that.
Always trying to make money somehow. And I heard they took away the NFL package, didn't they?
Oh, really?
With all the streaming bullshit.
Why is this?
See, that's what I'm saying. You don't know what we got around here.
You like this thing around?
Yeah, you need to be. Hang out, y'all.
So I hate this. Oh my God. You what?
Are we excused, Mr. Jackson?
Thank you.
Yeah,
I
I
was
just take a
just
look
going
at
into
them.
the
if you want to get my
real-
finger. Sometimes I put the.
Do you,
It's okay.
Are you sure?
We can share one.
are you sure?
Yeah, we're
Yeah,
good.
yeah.
Yeah, we're good.
Actually, we were.
Are there
See you tomorrow.